expect, over the last 16 months, and particularly over the last year, my colleagues and I have spent a lot of time counseling hundreds of different associations in connection with a whole variety of legal issues arising from the COVID-19 pandemic. We spent the most of last year, certainly the earlier part of last year, spending most of our time on helping associations like yours cancel or postpone or reschedule their meetings and conferences due to COVID, and trying to do so with little or no penalties, which we had tremendous success doing. We still continue to work on that front, but by far the kind of the landscape has definitely started to change, and many associations, I'm sure like yours, are contemplating a return to in-person meetings, which is certainly has a lot of legal implications, which I'm certainly prepared to talk about here today. At the same time, a lot of associations that have staff and have in-person office space are contemplating a reopening of their offices, which also carries with it a bunch of legal issues and risks and questions, which I'll be happy to talk about here today. And then there's been just a whole variety of other legal issues that have come up over the last year during the pandemic in other areas, from association governance to intellectual property issues and other things, which I'm also prepared to talk about here today. So the way this is going to go is the way it went last time when we did this, and I've done a number of other, done many webinars, probably close to 100 now in the last year, and many in this format, which is you ask your questions and I will answer them. This is a bit non-traditional in that I don't have any PowerPoint presentation. I do have certain things that I want to be sure to explain to you today, but I really want today's session, webinar, to be driven by your questions and the things that you're dealing with, the things you're wondering about, the risks, the legal risks you're trying to grapple with, and give you some good practical tips and suggestions on how to deal with those things. I am also, I will, after this webinar, I'm going to send to Melissa, who
joined the meeting,
will forward to you a number of different articles that my colleagues and I have written over the last year on a lot of this stuff. Links to those articles on our firm's website that should be helpful to give you some additional background for yourselves, and feel free to share them with your colleagues as well. And I should point out, we have a wealth of resources on our firm's website, hundreds of different articles and presentations on a variety of just about every conceivable association legal issue, COVID related and non-COVID related. And we also have dozens of recorded webinars that I've done in particular for a number of different organizations on a variety of different topics. The most recent one that we actually just posted today was a webinar I did a week or so ago about office leases and the challenges that those pose for those of you that might be trying to get out of your leases or reduce your office footprint or things like that. So just giving you kind of topics and ideas of things that you might want to ask about, and certainly things that you'll find resources on our firm's website. I see that someone posted in a chat a question of how many of you are planning in-person meetings in the next 30 days. If you're like most associations, and we represent about 350 right now, what we're seeing is that many associations are contemplating in-person meetings, but particularly during the second half of this year. There's not a lot that are contemplating in-person meetings in the next 30 or 60 days, but some are, particularly smaller ones. I'll actually be attending and speaking at the Georgia Society of Association Executives annual conference in Tennessee in the beginning of June. And also spoke at their in-person conference, the only one that I spoke at last year, which was actually a really good experience in seeing how associations can kind of safely deal with kind of having in-person meetings during COVID. Now, granted, that conference last October in Savannah, Georgia, was very different than, say, the conference that I'll be speaking at in June and those later in the year, particularly because of the arrival of vaccines and their widespread distribution, which is, of course, one of the issues that I get asked about probably every day, issues about should we require, do we have to require all attendees at our conference to provide proof of vaccination in order to attend? Um, can we require that our employees who are going to attend in-person conferences or any other kind of in-person meetings, travel, or whatnot on behalf of your associations, can we require that they be vaccinated? I get a lot of questions about requiring liability waivers from attendees at conferences before attending. So all of that, I'm allowing some softballs out there for you guys to ask about. But feel free to ask any of your questions frankly, in the chat box if you want to, and Melissa's going to kind of field those and and shoot them to me verbally. But if you want to, unmute yourselves and ask a question verbally, that certainly works as well. Whatever you guys feel comfortable with. So with that as background, who wants to get us started? And Melissa, I don't know if there's been a ton of questions. I can't read them all. So
we've got a couple. Let's start with, is requiring proof of vaccination, or could that be considered discrimination? And how do you handle having someone in your chapter who wants to attend an event but won't get vaccinated?
Great question. Not a shocker. In fact, I should have bet money with someone that would be the first question posed today, because it always is the first question these days. And it's an interesting one from a legal perspective. I'm a lawyer, so I get interested by the legal nuances of these things. And this is one that is interesting. And I've done a lot of research and digging on this, and also reading kind of what other attorneys are saying and advising their clients on these issues. So the first thing you have to recognize in this area is that the legal construct, the legal context for the analysis of these issues is very different when you're dealing with conference attendees versus employees of your organization. And I know some of your chapters have no employees, maybe just a management firm that you contract with. Some of you have one employee like yourself, some have multiple employees. But the thing to keep in mind is that there's a legal regime at the federal and state level that a lot of protections that apply to employees vis-a-vis their employer that do not apply in the context of attendees at conferences. So for instance, the provisions of Title VII of the Federal Civil Rights Act, which protect against religious discrimination. One of the effects of that is that if you are an employer and you have an employee who has what they refer to as a sincerely held religious belief in opposition to vaccinations, it is illegal to discriminate against them by requiring them to get vaccinated, before they can serve as an employee and participate, come back to the office, do things like that. What the law requires for employees, and I know that wasn't the question, but I want to kind of talk about that first. For religious discrimination purposes, if someone has a sincerely held religious belief, and I'm contrasting that to, say, a sincerely held political belief that they don't want or like or believe in vaccines, or even just a fear of getting vaccines because they're fear of the unknown or side effects, or because they haven't been used for that long, which we see and hear a lot, as you all know. But if it's a sincerely held religious belief, then you're obligated to make a reasonable accommodation for that employee, as long as with that accommodation they can still perform the essential functions of the job. What that means for most associations, for the type of work that most association employees do, is that if an employee falls into that category, the accommodation that obviously is the most readily apparent and the most workable is to allow that individual to continue to work remotely, and presuming they've been working remotely already during the last year. Now, in those rare situations where that's just impossible because the nature of the job, at least post-pandemic, requires them, to either be in the office, like for instance, say it's someone, in larger organizations, they have someone who's like delivering the mail to all the employees in the office, things like that, where you physically have to be there in order to perform the essential functions of the job. If that's their job, even if they have a sincerely held religious belief, they would not be able to perform the essential functions of the job, even with that sort of accommodation. And there may be other accommodations you can make to make them work, like giving them a private office space. I'm talking about for, say, a non-vaccinated employee who has that sincerely held religious belief. It's a very fact-specific analysis, but protection on the basis of religious belief is kind of one exception to the mandatory vaccination requirement for employees. Another one that's basically applicable because of the Americans with Disabilities Act, and a number of states have their own versions of the ADA, which apply to a lesser number of employees. Another one is that if someone has a medical condition that causes them to, for it to be unsafe and inadvisable for them to get a vaccine, that's another exception that you have to make. And the same basic construct, the analysis of, can you make a reasonable accommodation for them that does not pose an undue burden on the employer, but still enables them to perform the essential functions of the job. So bottom line, in the EEOC, Equal Employment Opportunity Commission, the principal federal agency that regulates these sorts of employee and HR issues, has said that generally speaking, you can impose a mandatory vaccination requirement on employees, say as a condition of returning to work. And they said because it's been established that non-vaccinated individuals pose a much higher risk to everyone than vaccinated individuals. Because of that, you can impose that a requirement, but you have to make those exceptions and accommodations for the sincerely held religious belief and for medical conditions or other disabilities that would prevent them from doing so. Yeah, go ahead, Melissa.
So before we get into the attendee aspect of this at events, we did have a question about how you verify that it is a sincerely held religious belief.
That's always been a tough one because this issue has come up before. It doesn't come up that often in the association world, but it has come up before. That provision of the Civil Rights Act has been around since the late 60s when the law was enacted. And there's no easy answer there. The guidance that's out there from the EEOC and court cases and other things, suggests that you can ask some questions, you can use your own judgment as to whether, as long as it's kind of objective, reasonable judgment as to someone, if that person is credible in that belief, or if you're 99.9% convinced that this is really a political belief, not a religious belief, and there's no evidence that suggests that it's stemming from a sincerely held religious belief. But fortunately, there's no easy answer, there's no easy test for how to do that. But if someone asserts that, it just puts it in a whole different category. It makes it much riskier. And I'd say, as a general rule, you want to try to accommodate that person, like I said, unless you're pretty sure that it's really a sham excuse and it's not credible and there's no real reason to believe it, because otherwise you're putting yourself as an employer at some real risk that someone could file a claim with the EEOC. Every state has their own kind of version of the EEOC, and then of course people can bring this what's called a private right of action. People can bring a claim themselves, whether it's through one of those agencies or through litigation. Oftentimes you have to go through the agency first to get that adjudicated, and then if they're not successful, get a successful outcome, they can bring litigation. There is some risk there, so you have to factor that into your calculations.
Okay, let's jump into the event side of things. I'm getting some requests there. Most of our chapters are single people, or they are not the employers, so they're more focused on how to handle in-person events. And
yeah, so I just wanted to lay that out there, so you understand it for those of you for whom that is applicable, but also to compare and contrast it. So here's what's different in the context of conference attendees. Now, of course, we're not talking about your own employees who are attending your conferences, because that's going to be governed by that same employee construct I just explained. But for conference attendees, Title VII of the Civil Rights Act doesn't apply to conference attendees. So someone asked, I think the first question you posed to me was about, can we be liable for some sort of discrimination against them? The ban against religious discrimination does not apply to conference attendees. A lot of people don't recognize that. And some of these laws do apply in other contexts outside of employment, where federal law makes it directly applicable, like in federally funded higher education institutions, like if you take federal money, which most colleges and universities do in terms of financial aid and whatnot, then by virtue of that, the federal government imposes those sorts of requirements in that context. But for association conferences, your attendees don't have those sorts of protections. And so it's a much lower risk because they have much fewer protections. The only conceivable protection that applies is the Americans with Disabilities Act, because that does apply. There's a section, an article within the ADA that applies to employment, but then there's a separate article that applies to what are called places of public accommodation. And basically that's been interpreted over the 20 or 30 years that the law has been in effect, is that if you are holding like an association meeting or conference at any kind of publicly accessible place, like a hotel, an event venue, a restaurant, things, a convention center, things like that, then that title of the ADA is going to apply. So if someone has anything that's a qualifying disability, which would certainly include medical conditions for the most part here, you do have to make a reasonable accommodation for them. But the reasonable accommodation may be if you're having like a hybrid meeting where you're having a virtual component, even though they might not be able to attend, like the receptions and the networking and that part of the meeting, which is important and everyone enjoys, but as long as they can still get access to the educational content, which is the principal focus of most of your meetings, I'm presuming, whether it's, a live stream, whether you're recording things and posting them later, or things like that, as long as they can get access to it, that is generally going to be considered, we think, a reasonable accommodation. That this is really a lot of untested area because there hasn't been much litigation because no one has really returned to in-person conferences. And generally, most people don't file a lawsuit because they can't attend an in-person conference. But bottom line is that, generally speaking, it is much easier to require mandatory vaccinations for conference attendees outside of the employment context. Just keep in mind, the ADA, and if someone, says they want some sort of reasonable accommodation, it's that same test. If you make a reasonable accommodation, can they still get, most of, the benefit of that program, and does it not pose an undue burden on your association? Now, what we're seeing, though, is that associations are all over the place in terms of whether they're planning to do that. Some are planning to make it mandatory. I'd say more that we've seen so far, again, this is still in the planning stages, most haven't done it. I'd say more associations than not that we've seen and talked to about this are not planning on having a mandatory vaccination requirement, but it's a business decision, right? There's a lot of politics charged in this, depending on where you're located geographically. We all know this is a very politically charged issue. And if you're in a state or a region, where there's a real anti-vaccination, sentiment, it may be politically really difficult, for you to require that. And frankly, from a business perspective, you may not want to. If you only get half the people attend because you have a mandatory vaccination requirement, you might only get half the revenues from conference registrations and sponsorships and exhibitors and all that other stuff. So it's a tough decision. I think we're going to see this evolve over time. I don't know if there'll ever be kind of a standard or norm, this year as to whether associations are going to require that. I'm just telling you from a legal perspective, it generally is permissible for you to require proof of vaccination. Then you get into issues of, well, what proof is sufficient? Because right now, with a few exceptions, like New York State has developed an app where you can, get the proof of vaccination put into that app, and then you basically, show that app when you show up in it. I think it's like a green check mark or something that you show that has all your information in there. But that information does, like the detailed medical information, to the extent it exists, doesn't get shared with the conference organizers. Just the fact that you are fully vaccinated. That you've had, if it's the Pfizer or Moderna vaccine, you've had your 2 shots and it's 2 weeks after the second shot. Or if it's Johnson & Johnson, that you've had the 1 shot and it's 2 weeks after that. When I say fully vaccinated, that's what I'm referring to. Yeah, go ahead.
Question. So when you say reasonable accommodation for those with medical exceptions, doing a hybrid event, is it potentially really expensive and also potentially disruptive to the actual experience in the room? So what would you define, how expensive is a reasonable accommodation? And
so it's a great question. And I alluded to this earlier, but let me reiterate it. The standard is, can you provide a reasonable accommodation that enables them to still get the essential elements of the activity without it posing an undue burden on the association. And I've heard this from many association executives that doing these hybrid events is very expensive, and particularly for a smaller organization, probably like many of your chapters, that may not even be an option. That may not be an option. So maybe though you can do things like, most presentations have a PowerPoint, presentation attached to them, sometimes other handout materials. At a minimum, try to make all of those things available, maybe on some, on your website, some page of your website where you're gathering all that and making that available to people. Frankly, I'm not overly concerned about the liability risk to an association in that situation, as long as you try to do something to make a reasonable accommodation, especially if you can show that financially it's just not viable or feasible for you to do some sort of a hybrid or virtual event. Maybe to the extent that you can record some of the sessions and make some of them available, that might help as well. I just don't think it's really a particularly area of high risk. And of course, you have questions of, are there other reasonable accommodations you can make? Is there a way you could have, I don't know, a separate meeting room, that's really much stricter protocols in terms of the social distancing and mask wearing and everything else for those who are non-vaccinated? That could be an option. That could be a reasonable accommodation. I'm not saying you have to do that. We really don't know yet. Certainly, I think I just saw a question pop up about, could we require masks for non-vaccinated individuals and not require masks for vaccinated individuals? So here, this isn't, in part, an issue of the ADA and what it requires, but it's in part also the broader issue of when and how could the association be held liable to an individual who alleges that they contracted the virus at your event. And in answering that question, the basic test is, was your associate, or first off, causation? Can someone prove that they caught, the virus at your event? Causation can be very difficult to prove unless you have some sort of like cluster of outbreaks or something like that. But if they can get through the causation issue, then the real question is, was your association negligent in how it operated the event? And so the test for negligence is basically, did you fail to meet the prevailing standard of care in holding your meeting? And the prevailing standard of care, it's a legal term, but how you define it is very fact specific, and it's a moving target for sure. I mean, even yesterday we had new guidance by the CDC about mask wearing, outdoors, saying essentially in a lot of situations, except very large gatherings, fully vaccinated Americans don't need to wear a mask when they're outdoors. So for instance, if you were holding an event and you were primarily holding it outdoors, or at least, the larger gatherings that are maybe a little more difficult to do the social distancing, things like receptions, relying on that guidance, even though it's guidance, it's not binding law, but it's still very relevant to defining what is the standard of care. So what the CDC says matters. And the CDC actually has put out, it's been out for a while, I'm presuming they're going to update it soon. They have written guidance for large meetings and large gatherings of individuals. And I have one of the articles I'm going to send to Melissa to send to you has a link to that CDC guidance. You should absolutely take a look at that. And you want to try to follow as many of those protocols as possible. But before you even get to the CDC guidance, which is advisory, it's not mandatory, but it's relevant. You first look to your state and the city or county to say, what does the state or city or county require? And there are many, actually most states, cities, and counties still have some sort of restrictions in place on large gatherings, like occupancy restrictions. Like you can only have 25% or 50% of the typical occupancy of that venue. Many still have social distancing requirements and things like that are mandatory. And so you absolutely need to be sure you're following whatever the guidance is that's in place at that time from the state and or city or county. Because in some places, like I believe in Maryland, close to where I am, there's guidance from the state, but then the governor has allowed cities and counties to impose more restrictive conditions if they want to. So you got to look at both look at the state and look at the city or county where you're located. So look at that stuff. Obviously, make sure you're complying. Look at the CDC guidance, comply with it to the greatest extent possible. Not everything's going to be possible because some things are just not going to be feasible or they're too expensive or whatnot to do. And then what you also want to do is you want to try to shift as much risk to the meeting venue as possible. The hotel, the event venue, the restaurant, the convention center, wherever you might be holding your meeting. Because if you look at the CDC guidance for large meetings, a lot of it applies to the venue. It doesn't apply to your association. It's kind of joint liability here, right? So, if you were negligent and not meeting the standard of care for the things that you can control, like it's the association's obligation to enforce mask wearing and social distancing. The hotel's not going to do that, but it's the hotel's obligation to do things like have proper sanitation and proper ventilation and proper air filters and all of those sorts of things. That's going to be on them. But what you want to really do is create at least a paper trail, if not in the contract itself, that imposes on the hotel or the venue that they will do, all of those things, that they agree to abide by the prevailing guidance from the CDC and whatnot. That will help, A, it'll help keep your attendees safer, but B, it'll help mitigate your liability risk because you're saying, look, we are not being negligent. We're doing whatever we can do to protect health and safety of our attendees, but we're also obligating the venue to do their part in keeping our attendees safe. So if you do those things to the greatest extent possible, it's going to be really difficult for an attendee, A, to prove they even contracted the virus at your event, but B, to prove that you were negligent. And so in how you held the event and that you didn't meet the standard of care. But that standard of care, when it comes to things like mask wearing, is relevant. So like, for instance, the CDC guidance still says even fully vaccinated people should be wearing their masks indoors, except when they are like eating or drinking. And so as long as that guidance still exists, and we expect it will exist for a while, you want to follow that guidance. If you acted contrary to that guidance, even if you believe it's safe, but you're acting contrary to the CDC guidance, I think that does open up some potential risk. But look, it's not black and white. This is an art, not a science. And the liability risks are one thing you have to consider, but the getting people to attend and having people have a successful conference and being happy and liking your association and you got to factor all those things in from a financial and a reputational and other perspective, and you got to balance all of those things. So I'd say the more of these things you can do, the safer you're going to be. Try to follow that guidance to the greatest extent you can, and that'll help to mitigate your liability risks.
Yeah. I'm sorry, we've got a question. Katie's got her hand raised.
No, this is such good info, like really valuable. But I was just going to piggyback on what Melissa put in the chat. So the liability for hosting in-person events does shift to the venue, and we can take venue regulations and say, these are venue regulations we are going by on top of mask wearing and social distancing.
So I agree with what you said, except it's not like all of the liability risk is on the
sure. Okay.
It's on you. But yeah, if the venue has more restrictive conditions than what the law requires, state and local law, because there's no federal law like that mandates stuff like this. It's just guidance. Or even if it's stricter than what the CDC recommends, you absolutely have to follow those things. But you have to do your part for the things that you're responsible for, like particularly policing the mask wearing and the social distancing, making sure you're arranging for proper setups of rooms and exhibit halls and stuff like that to allow for social distancing. How you arrange for food service and drink service and things like that is important. But look, even at that reception, the conference I attended last October, they did have one or two, I can't remember, in-person receptions that were indoors. They had a mask wearing obligation, but it's virtually impossible in a stand-up reception, around high top cocktail tables and things like that when people are eating and drinking. It's really difficult to enforce the mask wearing in those sorts of situations. So got to try to balance it.
Before we get to Mark's question, just there's some follow-up in the chat. So from a legal liability standpoint, are chapters covered if they put up signs, or do they actually have to go around and say, hey, you're not wearing your mask?
Yeah, it's a great question. And again, no clear answer on this. The more you can do, the better. I think that the general practice, what I saw at the conference last October, is there's signs in the public areas reminding everyone about the mask wearing and social distancing requirements. I went to my first sporting event since the pandemic, Washington Nationals baseball game this week. And I was actually a little surprised that they actually have masked police that go around and require you to keep your mask on in your seat, except when you're actually eating or drinking. And they actually come around, for people, even including me, because you forget about it sometimes. And, you take a sip of your beer or something, and then you put it down and you're watching the game and you don't put your mask back on. They actually come around and do that. I don't think that that's going to be necessary or the norm in an association context, but you're likely going to get, the one or two attendees that are kind of almost knowingly and intentionally, trying to not follow the rules. And if you witness that, then I think you really do have an obligation to say something to those individuals, again, to help show that you are not being negligent. But no, I don't think you have to designate some staff people to go around and, just constantly, harass people about that.
Yeah. Thank you for that. Let's get Mark Halby's question, and then I want to move on to liability waivers.
Yeah, I was going to get there next too.
Okay. Well, I may be jumping ahead as well. Then I guess my question in determining is it worth the risk or time and effort to do all this is, what is our absolute worst case scenario? And so I guess what I'm asking is, let's say someone does prove that they caught COVID and it was at our event and they sue the association. Is it the association that's ultimately liable to pay any judgment? Can they come after the board? Does the board personally have our businesses or our personal liabilities at some point at risk here? Or is it just the association's one laptop and our few $1,000s in the bank account would be the worst case scenario?
Pretty much what you just said. Yeah, the individual board members, there's something called the corporate shield. Presuming all your chapters are incorporated as nonprofit corporations. That corporate status provides a liability shield between most of the liabilities of the corporation, the association, the chapter, and the personal liabilities of, say, board members and officers and employees who run the organization. So generally speaking, as long as you're not breaching your fiduciary duties or things like that, you guys individually and your employers cannot be held liable for that. Worst case scenario is the association, probably as well as the meeting venue. If someone's going to bring a suit, they're going to sue both. They're going to make you co-defendants. And they would, again, this is what they'd have to prove. Not just that they caught the virus at your event. And that's one element. There's 5 elements of proving negligence. Causation is one. But the biggest one is that you were negligent in not doing your best to meet the prevailing standard of care. And that is going to be, if you're holding a halfway responsible meeting, that's going to be really difficult to prove, I saw one question about insurance. So in the past, pre-COVID, if someone had filed a claim that, that we've had these other viruses, obviously nothing to the extent of COVID, but we've had other viruses in the past, SARS and Zika and others, that did create some liability risk for associations and holding meetings and conferences. And in the past, what's called the commercial general liability insurance policy, which is the policy that is primarily applicable to meetings and conferences. I saw someone asked about E&O, but it's not the E&O or the D&O policy. It's going to be the commercial general liability. In the past, that would cover, claims for, say, your negligence that caused some harm to an attendee. But since COVID, when those policies come up for renewal, all or virtually all of the leading commercial general liability insurance carriers are now imposing either COVID exclusions or even broader communicable disease exclusions, saying they will not cover any claims that arise because of COVID or communicable diseases. So, it all depends on when your policy gets renewed, because they can't do that to an already enforced policy, but they can do that for renewals, and that's what they're doing. They started doing it in January for event cancellation insurance, and then now they're starting to do it, have already started doing it for commercial general liability insurance. So generally, that sort of claim, you're not going to have insurance coverage. But again, like I think it was Michael who asked the question, if you're holding a halfway responsible meeting, it's going to be very difficult to prove liability, that you were negligent. And B, I'm the lawyer, but don't let what I'm telling you be the driving fact. You got to balance it against all these other considerations, right? And you want to, create, people are excited. It's going to be your first meeting. Everyone's getting together. You want to make it fun and exciting, and you don't want to go overboard, but you obviously don't want to go beneath, generally speaking, what the prevailing standard of care is.
So let's talk waivers. Do they actually work? Should we be doing them? Are they worth bothering with?
When we say a liability waiver, what we're talking about is something that an attendee would sign, but really not usually physically sign, click and accept as part of the registration process, or on site if you're doing on-site registration, on whatever sort of, iPad or screen or whatever you might be using, or even an app on a phone, where they click and accept that they understand and agree that COVID is a dangerous virus and it's highly transmissible. And no matter what you do, you can't absolutely guarantee that they won't contract the virus. And if they do, they agree to not hold your association liable. Should you do that? Absolutely, in my opinion. It's a no-brainer. Do they always work? Do they always hold up in court if they get challenged? No. Like, for instance, if a plaintiff could prove that you were grossly negligent, not just negligent, but grossly negligent, or even engaged in reckless conduct in how you conducted the meeting, the liability waiver would likely not be enforceable in most cases. Or sometimes if the liability waiver is just buried in the the terms and conditions of your conference registration stuff, and there's not some affirmative, I click and accept that I agree to this, but you just say by attending the conference you agree to all of these terms and conditions, including a liability waiver. If it's kind of buried in the fine print, so to speak, that's another basis that these waivers get tossed. But if you do it right, if you make it clear and understandable, don't have too much legalese, and then have something where they affirmatively click and accept that they agree to that, I think it's a no-brainer you should do it. And that does seem to be the norm where a lot of associations are heading in terms of, at least for this year, requiring this sort of liability waivers. One of the articles I'm going to send you is about liability waivers for association conferences. And in there, there's a link to a model association liability waiver that we put together that you are free to use. And one last thing on this. What the liability waiver we drafted, it's very clear, plain English, easy to understand, which is important, again, for enforceability, but also for your attendees understanding what they're agreeing to. So the first part has what I just described. The second part has essentially kind of an affirmation by the attendee that they will abide by all of your rules. And I'd actually probably even call it, liability waiver and agreement to abide by conference rules or something like that. So it's very clear that basically they're saying, I agree to follow all the rules that you guys require for conference attendees: social distancing, mask wearing, not going off site, to crowded bars and nightclubs at night and then coming back to the conference during the day. All of those sorts of things. It has two benefits. One is it hopefully reminds people not to engage in risky activities and reminds them that you are going to be enforcing those rules and they agree to abide by them. But second, it also helps on the negligence front to show that you're not being negligent because you're actually requiring your attendees to do that. So again, I think it's a no-brainer that you should do that. And I'll make sure all you guys get that as soon as this is over.
So we've had some requests in the chat, Jeff, for like a sample liability waiver that FPA can put out. So if you're okay with it, I'll work with you to create that for everyone.
That's what I'll be giving you. Yeah, you can feel free to,
Perfect. We'll just brand it.
Put in, the FPA, branding and whatnot, and that's absolutely fine with me. We have several, since we work with so many clients on these already. I have several other samples that we've kind of turned into models, things that we worked on for clients. And I'll send you a few of those as well, so you can see what you guys like. Some of them are a little more legalistic and have a little more in there that I'm not sure is necessary or even advisable, but you guys can decide. I like to share as much as possible, and you can decide what works for you guys.
Thank you for that. I've got another question in the chat about whether someone who has had the virus and therefore has antibodies for the virus, if we should still require vaccinations from them.
So again, you look to CDC guidance on this, and the CDC has put out guidance on this where they've said that having the antibodies is not the same as being vaccinated. From what they know so far, and there's still much more that they don't know than they know. But for one, the protection doesn't seem to be as robust. And second, so far, again, they really don't know because it hasn't been that much time. They don't know that it lasts as long. And I mean, I'll give you a personal example. I found out early in COVID that I had the antibodies. I was never symptomatic. I never even knew I had the virus, but I had the antibodies. You just see it was kind of showed up in a random blood test at a physical. I'm going to ask them to test for it. And then, when I was curious, I just had several other blood tests because I was doing some travel. And they kept showing up. It's just like a yes or no. Either you have them or you don't. It doesn't give you a level or anything else. But then at one point, they went away. And then one more time they came back, and then I got vaccinated. But who knows? But bottom line is, my example is irrelevant. The point is, CDC says it's not enough. It's not the same as being vaccinated. And so I would say if you're going to have a mandatory vaccination requirement, that you do not allow just the presence of antibodies as an alternative. And the other, I meant to mention this earlier, there's a federal law called HIPAA, which deals with personal health information. And there is a lot of guidance, particularly in the employment context. I'm not sure to the extent it would apply to conference attendees, but bottom line is you generally do not want to be asking any personal health information, from folks. Now, whether you're vaccinated or not, they have said is not considered personal health information. But to the extent you're looking at blood work results, which is the only way you'd be able to show antibodies, I think that's a slippery slope when it comes to HIPAA. But for the reasons I said before, just from a basic negligence standpoint, in light of the CDC guidance, unless that changes, if you're going to have a mandatory vaccination requirement, I don't think you make exceptions for that.
Thank you. Okay, so if we're requiring vaccinations, is that something that we put in the online registration? Can we, please confirm that you're vaccinated, and they hit yes, and then we've done our due diligence?
Well, that's a tougher one. And because, like I was saying earlier, actually I started to talk about this and I got distracted, went down a different path. Because we don't have, like in some other countries, like in Israel, they have an app that everyone, or several apps that have been kind of approved by the government to provide proof of vaccination. And it's easier in countries like that have a centralized health system, like in the UK, because everything can just feed right into that. We don't have that here in the US. But there is some thought that because it looks like larger concert venues, sporting venues and whatnot, theaters may well be requiring vaccination as a condition of attendance. Some already are. That there really needs to be some electronic apps, and the federal government's working on this right now to try to create standards for this. Not a federal system, but standards to ensure, privacy and data security and things like that, and veracity to make sure, that these things are real and aren't just, someone's not just creating it on their own. Until we get there, you're going to need those of you who are vaccinated, like myself, you get this little, card. It's like a business card, a little bigger, that has the CDC logo on there, and they handwrite, the date and type of vaccine that you got. That's the only proof of vaccination that exists right now. And I'm sure you've heard stories that these are being forged and sold, by kind of scam artists online. But look, right now, until there's some like government endorsed apps or something like that, or some apps that become, kind of widely accepted to be safe and reliable, you're going to need, if you're going to require a vaccination requirement, just having someone self-certify that they're vaccinated. Again, it's that balance of how far do you want to go? But I would say that you need to require some sort of proof, whether it's, if you want to do it electronically, they take a picture of, they say not to disclose all parts of the card because people can use that to, for identity theft and things like that. But the relevant portion that shows that you are vaccinated and has your name on it, maybe they take a picture and they send it to you, or they show it to you upon arrival. But some sort of, affirmative proof to the whatever extent that proof exists at the current time of vaccination, I think is going to be important if you want to show that you're not being negligent. Just requiring someone to self-certify, it's better than nothing, but I'm not sure it really helps you. And look, this is going to be like everything else in COVID. It's going to be an evolving process. And what I'm telling you now, the advice is probably going to be very different 6 months from now, when the standards evolve. But right now, if you were having a conference in the next 30 days, I would say, yes, you definitely want to require some sort of actual physical proof of vaccination.
So either they upload a picture during the registration process, or they bring the card with them and just flash it to get it.
Yeah.
Okay. Is there
By the way, all of that being said, I'm not sitting here telling you that it's my advice for you to impose a mandatory vaccination requirement. I'm not saying that at all. That is, it's a difficult decision, and it's going to be based on geography and politics and other things like that. I'm just saying, if you go down that path, that's what I'd recommend.
So if for our chapters who are looking at, planning their in-person event, if it were you, what would you do? What steps would you go through to make sure that the chapter is covered? Would you require vaccinations? Would you make them sign a liability waiver? Would you, I don't know, make sure it's a hybrid? Like, what steps should they go through to make sure that they're covered?
Well, I mean, I've already spoken to a lot of the issues, and you've heard my thoughts. Do I think that everyone should require attendees as a condition of attendance to agree to a liability waiver and, affirmation of how they're going to conduct themselves? Yes, absolutely. That's a no-brainer. On the mandatory vaccination, I can't give blanket advice. If you're in a chapter in Florida, for instance, where the governor has actually signed a bill into law, making it illegal for, I can't remember, I don't think it applies to private entities like associations, certainly government entities, government agencies cannot require vaccinations as a condition of participation in that event or attendance or going to that particular venue. That's a very different analysis than if you're in many states in the Northeast. That again, it's the politics involved in that. I just can't give you blanket advice. I just was giving you advice. If you go that path, keep in mind the ADA, Americans with Disabilities Act, and keep in mind some of the issues about proof of vaccination and things like that. In terms of kind of a checklist, I don't have a checklist. If you look at the CDC guidance for large meetings, it essentially is a checklist. There's a lot of things in there. Again, a lot of those things relate to the venue. And so, as I said earlier, you want to get, say it's a hotel, get the hotel sales manager or general manager or someone whoever you're dealing with to agree in writing, even if it's just an email exchange, that they will abide by kind of the prevailing CDC guidance for large meetings. And I've seen some association clients of ours even detail some specific things that they're obligating the hotel to do. And then I said certain things are going to be on you, on the association to do. It's an evolving thing. For instance, the risk of transmission through surfaces, in the beginning of the COVID, everyone thought it was a super high risk thing. Now they're saying it's virtually, it's a really small risk. So that, factors into the analysis as well, about how far do you go, and maybe things like food service. Like when I attended that event in Savannah in October, they had like plexiglass shields up, in front of where the people were kind of putting the food. Like you tell them, almost like you go, like if you're going to a buffet where someone is serving you behind the glass shield, you tell them what you want, and then they put it in a container and they close it up and then hand it to you. Things like that. You ought to consider, but there is no one size fits all checklist. I'm sure some folks have put some together. A little Google searching would probably turn up some good things, but we unfortunately don't have one at our firm.
Thank you for that. You mentioned, working with the venue to get them to acknowledge their part. What we saw in the chat as you were talking is that some of the contracts for these venues are being written so that it puts the onus of responsibility back on the associations. Is that something we should be accepting, or should we be putting it back on them? Or
so this is nothing new in terms of I've spent my whole career working on, among other things, this, negotiations between associations and hotels for meetings, and it's constant battle of who's responsible for what, who's going to do what, all of that. I would say that, look, if they're going to put the onus, for instance, on policing mask wearing and policing social distancing, and if you do temperature checks, which I don't think make a lot of sense anymore because of asymptomatic people don't have a fever, but if you're going to do those are things that the association is going to have to do for sure. Whereas other things, sanitation, food service, ventilation, all of those things, you can't do those things. You can't, you're not going to go around. I mean, they might obligate, your exhibitors, for instance, to wipe down, disinfect any surfaces on every half hour, every hour during the exhibit hall hours, or something like that. Maybe something like that could be the onus shifted on you, but a lot of it's going to be on the hotel. And as I said, that CDC guidance is actually more applicable to the venues than it is to the associations who's sponsoring the meeting. So yes, you should push back on things that are unreasonable or too expensive or not realistic. And I did see a number of comments pop up about, this puts staff and especially volunteer leaders in an uncomfortable, awkward situation, and it does. And I'm suggesting you got to find the right balance. I am not suggesting you become that guy at the National Stadium who was going around and really pissing everyone off that night, because he was just being really unreasonable. In DC, you can go into restaurants and sit at a table and have your mask off the whole time, but at a ballpark where there's social distancing, you couldn't do it. I just thought that was too much. That was over the top. When you're walking around inside the stadium and all of that, completely get it. But anyway, those are my thoughts on that. Yeah, and then like someone said here, you're also balancing that with, as a lot of people are still hypersensitive about COVID, even after they've been vaccinated. And you want to make them feel comfortable as well. So you got to strike the right balance there.
A few minutes left. Any other questions for Jeff? I think I covered everything that I saw.
Let's see here.
I don't have time to type it. Can I just ask it?
Absolutely.
So Jeff, even if you do all the things right, somebody could still bring an action. They may not have much of a chance of prevailing, but you still have to defend. And I keep looking for that kind of, what do I need to have in the bank if my chapter on a business basis is we're going to have some in-person meetings, we're going to do this. And I think this is what Mark was getting at. Like, is it 40,000, 50,000, 60,000? How much money do we need to successfully initially defend ourselves against even irreverent, impossible attacks?
It's a great question, and especially if you don't have insurance coverage, and if you have a renewal policy that has the exclusion for COVID and communicable diseases, which I think virtually all of them do now, or will. That's what I'm told by the insurance brokers. You're right. Anyone can sue you at any time, even in a baseless, groundless suit. And you have to defend it. Now, if it's completely baseless and groundless, you can often get out early on a motion to dismiss or a motion for summary judgment. But this is probably way more than you want to know. But in litigation, if it's a fact-specific case, if the case really turns on the facts of, what did you do and what did you fail to do, the facts of what actually transpired, a dispositive motion, like a motion to dismiss or summary judgment, are generally not appropriate and they won't be granted, which unfortunately means that the case would proceed, through depositions and interrogatories and perhaps even trial unless the matter was settled. All that being said, there is nothing to suggest so far that we're going to have this rampant, outbreak of suits against associations. Hopefully, we're already seeing, the case rates go way down. Hopefully we'll continue to go way down. So the more people that get vaccinated, plus more people that have antibodies, the lesser risk that someone will in fact contract the virus at your meeting and event. So all this has to factor in your risk calculation. If you got sued and you had to defend it, it depends where. It's usually going to be in state court, but you're probably talking at least $50,000 to defend a suit that doesn't get, you can't get a dispositive motion granted early, and could well be more. But again, like you got to think the damages, which is another element of negligence claims. What sort of damages can the individual prove? Like if they contract COVID and they get a bit sick for a few days and then they recover. Of course, we don't know long-term effects yet and things like that. It's going to be hard for them to prove significant damages, which is likely going to make it less likely that they bring a case in the first place. If there's not a big pot of recovery, because they have to prove actual damages that they incurred. Pain and suffering might factor in, but I'm just saying, I don't, maybe I'm getting a little bit ahead of where we're at in the pandemic recovery, but I'm not overly concerned about this. If you, like I said, do your very best to try to have a safe, healthy meeting, balancing all these considerations, using the liability waivers, reminding people of the rules, getting them to agree to abide by the rules, getting the hotel to agree to do their part. I think the risk of being sued is very small to begin with. But I mean, frankly, you should always ideally have some reserves, because I think cases in this area, are probably, to me, the least of your worries. But lots of other things you do, you put out publications that can infringe others' copyrights and defame people, and you got antitrust cases. You have slip and fall accidents and things like that. Certainly employee-related employment suits. If you have other employees, these are the things that you're much more likely to get sued for. Now, granted, you do have insurance for a lot of those things. Breach of contract, however, you can't generally get any insurance for. So you always should have, ideally, some sort of reserves to protect, as there always are things like that you might get sued. Your insurance might not cover it because of various exclusions or things like that. So it's a good idea to do that generally. I just don't think we're all focused on these risks, and I'm telling you how to mitigate the risks, but I don't want you to give the liability concerns too much weight compared to the other concerns. You got to strike the appropriate balance.
Thank you so much for your time, Jeff. We are completely out of time. It's now exactly 11 o'clock in California. So thank you to everyone who joined. I will be posting this to Connect so you can reference it after the event. Thank you all.
Thank you, everyone. Take care.